In today's video, we're going to look at the top 5 reasons that living wills fail. My name is Gregory Singleton. I'm an estate planning and probate attorney with Signature Law. Signature Law is an estate planning and probate law firm that serves the Twin Cities and greater Minnesota alike. Just a reminder, if you like today's video, please feel free to hit that like and subscribe button. It really does help support the channel. Also, we're still having sound problems with my other camera, so we're going to get by with this one and keep on trekking until I get the other one fixed. And lastly, couple caveats before we get going. First of all, these videos are for educational purposes only. They are not for legal advice. And second of all, we're going to be talking Minnesota law here. So if you're in another jurisdiction, make sure to talk to an attorney in that jurisdiction before you go to plan your estate. So the top 5 reasons that living wills fail. Now remember, a healthcare directive in Minnesota is 2 documents in most states. One is a healthcare proxy that appoints your healthcare agent and gives them the authority to make decisions on your behalf. The living will, on the other hand, is a document that says what decisions you want your healthcare agent to make. So now today, we're just not going to look at the healthcare proxy. The main failure with a healthcare proxy is just not doing it. With the living will, there's a few key mistakes that people make that can be addressed, and you should keep in mind when you're doing a living will. The first one is ambiguity, and this is probably one of the most dangerous ones. I could talk about this one for quite a long time, but the definition of an ambiguity is if something in your living will has multiple meanings or has no clear meaning whatsoever, or has contrary meanings that conflict throughout the document. These tend to be inherent if we're not careful, mainly because, first of all, when we're thinking about our death, we are sometimes like to wax poetic and talk in very flowery terms. Well, that can actually confuse the matter. Second of all, we're in foreign territory here if we're doing the living will ourselves. We're talking medical terms, we're talking legal terms, and we may not know exactly what those are. Here's a couple examples that I see quite a bit. The first one is, I don't want to be a burden on my family. Well, what does burden mean? Is that financial burden, emotional burden? I don't want to impede on their life. What does family mean? Are we talking the healthcare agent, or are we talking everyone in general? What if your healthcare agent isn't your family? Another example, this is a very common one that I think people need to fix in the drafting, attorneys need to fix in the drafting, but it's the difference in life support and organ donation. People will say, if I'm in a persistent vegetative state, I do not want to be on life support. They'll also say, I want to be an organ donor. So what's the question? When you die, if you're in a persistent vegetative state, they will keep you alive to harvest your organs if you want to be an organ donor. But if you put in your living will, do not keep me alive no matter what if I'm in a persistent vegetative state, now we've created conflict in the document, and we need to reflect that so that we don't have that conflict. The result of having an ambiguity in your living will is, first of all, you may not get what you want, especially if there's a conflict or people just aren't sure what it says. Second of all, if there's a disagreement and multiple people see multiple meanings in it, in your living will, and they disagree about what the living will actually means and what your wishes actually are, you might be inviting your family and friends into court. And as I tell everyone, avoid court as much as possible. The final real problem with ambiguity is, let's say there's just one healthcare agent, but they're not sure when you want to pull life support, life sustaining measures. They're going to have to make that decision at some point. Let's say they make the decision to pull life sustaining measures. That decision is going to haunt them for years. I've seen it. It's terrible. So don't have ambiguity. How do we solve this? Work with an attorney or somebody, a social worker that has worked with living wills. Do so on a daily basis and can help make sure that you do not have ambiguity in your living will. The second way that living wills fail is people don't understand the limitations on living wills, or realistically, what a living will is. A living will is, by definition, an opportunity to express your wishes for treatment. But this is patient wishes only. No, doctors do not read living wills. They all say, Dear healthcare agent, tell me what the wishes are of the individual. You're their proxy. You're speaking on their behalf. They are not going to go through the living will and try to determine that themselves for a variety of reasons. Um, Healthcare proxy just authorizes someone to allow or it authorizes someone to let your wishes be known. A living will is not a medical order. I know we call it a healthcare directive, but it is not a medical order. If, for example, in your living will, you say, if I have dementia and I get a cold, I want chemotherapy, they're not going to give you chemotherapy. It's not an option. That you can't express your wishes to have something that is just not allowed. You can say in your living will, I want physician assisted suicide. If I'm incapacitated, I want euthanasia. If it's not legal in your state, they're not going to do it. And quite frankly, I'm not aware of any state where the healthcare agent can they can remove life support, but they can't do physician assisted suicide on your behalf. That's just not I'm aware of allowed. So there are things that are medical orders that do not resuscitate or a pulsed, which is a physician orders for life-sustaining treatment. You have to have a doctor help direct these things, not an attorney, but a doctor, because it is a medical order. So in some states, a healthcare agent can execute a pulsed in most states. But until you have that pulsed, POLST in place, it is not a medical order. The third way living wills fail is that they're not comprehensive. Now, here's the most common situation I see a lot. There is I think in every state, or most states at least, there is a statutory form for a healthcare directive. And it'll have, in some states, it just has one or two questions. If you're in a persistent vegetative state, do you want to have life-sustaining measures? In Minnesota, we have a little bit, one that's a little bit beyond that, goes into some of your goals, some of your fears, and a few other things. There's maybe 10, 15 questions. But is that enough? Remember, a healthcare directive can have, or a living will can have a lot of information in it. For instance, there's, of course, the declarations, which is the quintessential pull the plug if I'm in a persistent vegetative state. But what about various scenarios? What about different types of life support? What about pain medications? What about blood transfusions? Is this stuff that you want? You can also put in your values in your life, in your living will, and that can make a big difference for your healthcare agent who has to make the decisions. What are your goals? What are your fears about medical treatment? What are family considerations? One that I've seen that I find interesting is some age considerations. Some people will say, if I make it to the age of 95, don't do any major life sustaining measures. Let me go. You probably need a pulse in that case, by the way. But these are things you can include in the living will. Treatment preferences, specific types of treatments, opinions on specific types of treatments. Do you want to authorize experimental treatments? Big one in Minnesota. Do you want electroconvulsive therapy and neuroleptic medications if they're recommended by a doctor? You can include in a living will post-mortem decisions, such as organ donation. Do you want an autopsy unless it's required by law? Do you want a burial or cremation? Here's a big one. If you want cremation, what do you want to have happen to the ashes? That causes a surprising amount of family fights. What are your religious preferences? How do you want the body treated? Other things you can include that is not in a lot of healthcare directives or living wills is going to be provider preferences. Is there a facility that you want to be treated at? Or is there a facility you absolutely don't want to be treated at? Are there medical providers that you want or want to prohibit from treating you? What type of facility is important to you? Some people say absolutely no nursing homes unless it's required. Um, Involvement of non-agents. That's another big one that you can include to round out your living will. And when I mean non-agents, I mean of a non-healthcare agent. Who do you want to have take care of your pet if you're incapacitated? Who do you want to have your healthcare agents to contact if you're incapacitated? Who do you want to prohibit from visiting you in the hospital if you're incapacitated? That's an important and interesting one, and I've seen it come up quite a bit. All of that said, what about mental health? There's a big difference between being in a coma and having dementia. Legally, you're incapacitated or can be incapacitated in both situations, but the treatment specifications might be different. And there's a lot of things specific to mental health treatment that you won't find in most healthcare directives. The fourth way that living wills fail, and this is the easy one, is they don't get distributed. Generally, attorneys don't distribute the healthcare directive or the living will. It needs to go to your healthcare agent. It really needs to go to your doctor. If there's an online portal such as MyChart in Minnesota, you're going to want to make sure the hospital puts it on MyChart. In some states, they have a depository for all healthcare directives and living wills to go. We don't have quite have that in Minnesota, but in some states they have it. Make sure it gets there. If you're going on a road trip, put a copy in your glove box. If you have a family cabin you spend a lot of time at, make sure you put a copy at the family cabin. Similarly, you should have a laminated card that goes in your wallet or your purse that says, in case of emergency, contact, and then list your healthcare agent, your successor healthcare agent, your second successor healthcare agent, and their phone number so that hospitals can reach out to them. If you get in trouble and you go to an emergency room and you're unconscious or whatever it may be, they will take your personal effects, usually two people, two physician assistants or whatever, nurses or whatever it may be. They'll take your personal effects aside and they'll look for a in case of emergency card to contact. If your attorney doesn't prepare one for you, just make one of your own, go down to the store and get it laminated. It makes a big difference. The fifth biggest way that living wills fail is that they aren't done. I mean, very simply. You could say that about any estate planning document, but it's specifically towards living will. What I see a lot is people go to an attorney. The attorney will sometimes they'll have their own form. Usually, they will only have just the statutory form. They literally print out the statute and format it nicely. They'll do the healthcare proxy and appoint your healthcare agents and get that executed properly. And then they won't fill out the rest of the living will with you. They won't review your answers. They won't make sure your language is going to work and doesn't create problems. Um, a lot of times, what people do is they get that, they have the healthcare proxy, they put it in their little binder or their little envelope, throw it in their safe, throw it in their safe deposit box. By the way, a safe deposit box is a terrible place for a living will because you can't get to it. Or they'll just throw it in a file cabinet and they'll never think of it again. And when the time comes and the healthcare directive is needed, and the healthcare agent appointed by the proxy looks at the living will for those directions on what decisions to make on your behalf, and there's nothing there for you. And there's nothing there for them. And it's going to lead to decisions that haunt them for a very long time if they think they might make the wrong decision. This is an easy one to solve. Fill it out. Uh, And there you go. That is my take on the top 5 reasons that living wills fail. I hope you liked today's video. If you did like today's video, please feel free to like and subscribe. It really helps the YouTube algorithm. We do a new video every other Wednesday. If you have questions or comments, leave them in the comments below or send me an email. Hopefully we'll have the camera working up and working for the next couple of videos, but we'll see. Otherwise, until next time, this is Gregory Singleton with Signature Law.